Okay, let's talk about title. Okay, this is actually now getting legal title to a piece of property. In some other chapters of the overall property lecture, we talked about the real estate contract. We've talked about equitable title, the right to do something on someone else's property, rights and land. Now we're going to talk about title, getting legal title to a piece of property. Okay, so we also talked about in a previous chapter how there's two pieces of paper for legal to transfer legal title to a piece of property. The first piece of paper is called the real estate contract. This piece of paper that we're now going to talk about transfers legal title, and it's called the deed. That is correct. The deed is the piece of paper that transfers legal title on the day of closing. Day of closing is simply the name of the day. We go to the office and sign the deed, and the deed will transfer legal title from the seller to the buyer. Okay? The deed. Generally, in a warranty deed, we'll talk about different kinds of warranty deeds soon. Just know, in a warranty deed, if I convey title to you via a warranty deed, yes, they'll have to tell you. In a regular warranty deed, I'm warrantying, I'm making promises. There's generally 6 warranties in a warranty deed. 6 promises. 3 are called present, 3 are called future. 3 present warranties. The 3 present are as follows. The warranty of season. I'm promising that I actually own the property. The right to convey, that I have the legal right to convey title, transfer legal title to it. And covenant against encumbrances. I'm making a warranty that there are no encumbrances. Warranty deed, 3 of the 6 are called present. Season, right to convey, and covenant against encumbrances. I say present because if those are breached, they're breached at the time of conveyance, on the day of closing. So whether I own it, I have the right to transfer it, or there are no encumbrances, if I breached any of those warranties, they must be breached on the day of the closing and the day of conveyance. If you do it later, it's too late. That's why they're called present warranties. There's other warranties. The other 3 are as follows. Warranty of quiet enjoyment, that the grantee will not be bothered by any future claims. Warranty, simply that I will defend any claims that happen to come up against you in the future. And further assurances, the warranty of further assurances, that I promise to do whatever it takes to fix any defects in title. So the future warranties are quiet enjoyment, nothing will happen. Warranty, I'll defend you if it did. And 3 further assurances that I'll fix any problems if they come up. Those are called future warranties and will last forever. 3 present, if breached at the time of conveyance. 3 future. Have your little card with the 6. Keep the first 3 separate from the bottom 3, and we're good to go. It's just definition. If we're doing one of these warranty deeds, I'm warranting, I'm promising these 6. There's a general warranty deed and there's a special warranty deed. If I give you a general warranty deed, I'm promising that all 6 of these things, there's no problem with any of the property, that all 6 are in the deed, and I'm making these promises since when? Forever. In a general warranty deed, I'm promising you that everything has been okay with the property since the property was developed or created. General equals forever. Now, I'm just not telling you that everything's okay while I owned it. I'm telling you and I'm promising you that everything's okay for the last 150 years. So if after I give you the general warranty deed, someone comes along and says there's a lien on the property since 1932, almost 100 years ago, blah, 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 whenever, will I be in trouble? Yes, because I gave you a general warranty deed, which means I'm promising you that everything has been okay since forever. What about a special warranty deed? Special warranty deed simply means I'm promising, warrantying, that everything's been okay since I had title to the property. Special warranty deed means I'm promising you that everything has been okay while I own the property, the current seller. General means everything's been okay since forever. They'll have to tell you what they're talking about. General versus special, it literally is just a definition. Quitclaim deed. What if I give you a quitclaim deed? Then I'm literally quitting my claim. I'm literally not promising you anything. Quitting my claim. I may be giving you perfect title, I may be giving you no title, but I'm not making any promises. So if I give you a quitclaim deed and then there are problems with title later on, can you come back and yell at me and sue me? No, because I didn't promise you anything in the first place. This is like the great movie The Money Pit, right? If I sell you a lemon of a house, all kind of problems, and you were stupid enough to take it via quitclaim deed, then could you sue me? No. But if I gave you a warranty deed, yes. General warranty deed for any problem since forever. Special warranty deed, only problems that existed while I owned the property. Now you're asking, why would anybody be stupid enough to give a quitclaim deed? This is one of those situations where for the most part on the bar, who the hell cares? Just a definition. But just so you understand, many times in real life, as much as I hate talking about real life, in a quitclaim deed, it's usually in between family members, maybe even a business partner. But if, God forbid, grandma, an older relative, is very ill, and you're afraid, God forbid, something's going to happen, then the relative can quitclaim the deed to another family member. You're not worried that grandma's ripping you off with warranties. You just want a quick way to convey title to the property. So if I quitclaim the property, I'm just being able to transfer title quick and efficient. I don't have to do title searches and hire title companies and research, is there any problem with the title? So in those kind of inter-family, sometimes inter-business, I just want something quick and get it out of the way without all the time delay, that's when you would quitclaim the property. In a normal situation, you go buy a house in the real world, you got to be an idiot to take it by a quitclaim deed, obviously, because you're basically, it's literally let the buyer beware. Warranty versus quitclaim, keep them separate. Good? Good. The formalities of the closing, the formalities of having the deed on the day of closing, formalities to transfer legal title in the first place. Number one, like we talked about before with another matter, does the deed have to be in writing? Yes, to comply with the statute of frauds. Good. Two, the big one, delivery. There needs to be delivery of the deed from the seller to the buyer. Okay? What does delivery mean? Does it have to be physically handed over? No. Delivery is all about my intent. Did the seller express unconditional, unequivocal intent to give you the property? If I've done everything I can to relinquish all control to the property and I want you to have it, I can argue I have effectively delivered the property and therefore we have a conveyance. Even if it physically doesn't end up in your hands, can I argue that I've delivered the deed to you? Yes, as long as I've expressed my intent. What if there was no intent? What if you ended up with the deed somehow and I never wanted to give it to you? Or I wasn't sure if I wanted to give it to you. Then there's no conveyance because there's no delivery. Because delivery equals intent. I'm making a big to-do about this for the simple reason. There's going to be a question about delivery. Sometimes about that there was delivery and sometimes that there wasn't delivery. Sometimes I could have both. How will I know which one's which? It's all about what the seller or grantor's intent was. And if you dumb down the hypo and say, basically, this is all about John not really wanting to give him the property, this is the intent thing. Oh, intent equals delivery. This is how you talk yourself into the correct answer. By dumbing it down and saying, oh, is this about whether he wanted to give it to him or about whether he didn't want to give it to him? And if I did everything I could and it just physically didn't end up in your hands, I'm going to argue there was proper delivery, or somehow you took it or it ended up in your hands and I didn't want that to happen. No intent, which equals no delivery, which equals no valid conveyance. Acceptance. Delivery is what I have to do to you. You're the buyer. Acceptance is presumed. You don't have to, like in regular contract law, say, I accept. Acceptance of a deed is presumed unless the facts say otherwise. Okay? If I'm selling you my house, and you find out that I'm a Jet fan, and you love that terrible team in Miami with the fish on the helmet, and you're disgusted by the Jets, and once you find out that I'm a Jet fan, you say, take your deed, paint it green, and take it. I don't want this frickin' thing. Do we have a valid conveyance? Well, I'm going to say acceptance is presumed, but you're going to say, now I'm telling you I don't want it. Acceptance is presumed unless the buyer rejects it or says that based on the facts shows that you don't want it. So if you just grumble, oh, what a slime ball, he's a Jet fan, oh, they're so terrible, oh, what a moron. Basically, do we have a conveyance? Yes. But if you throw it back in my face, then you've expressed that you're obviously not accepting it. What's the basic rule? Acceptance is presumed. So if the fact pattern is silent, it's presumed that you have accepted the deed. Merger, talked a little bit about this in a previous chapter. The day of the closing, there was the real estate contract and there was the deed. What happened to the contents of the real estate contract on the day of closing? It merges into the deed. And now all of the terms, all of our obligations, all the conditions are governed by the deed itself. That is correct. Good? Good. There needs to be a legal description in the deed, a legal description of the property. Usually this is by the metes and bounds, a property located at 20 degrees times 4 degrees north, etc. Why? So the description of the property has to be reasonably definite. Reasonably definite. So someone would know where the property is. If I have the only house in the neighborhood with a big rock in front of it, excuse me, a big rock, can I say in the description of the deed, this is the house with the rock in front of it? If that's reasonably definitive, because nobody else has a big rock in front of it, if I, in the front of my lawn, take one of those mowers, the power mowers, and I carve into the grass the Jet logo, wouldn't that be reasonably definite? Oh, that's the house with the Jet logo. Yes. But in a lot of the communities all over the country now, you drive down different neighborhoods and every house looks exactly the same. Correct? So to say that my house has the white fence in front of it, if 4,800 houses have white fences in front of it, obviously, that's not reasonably definite. So usually it's by some sort of metes and bounds description. Just know that the description has to be reasonably definite. Usually metes and bounds, but any other way you describe the property, can a reasonable person know where you're talking about? Legal description. So there will be a question on delivery. Totally separate question on acceptance, totally separate question on legal description. Each one of these rules gets its own hypo. And the other one, identifiable grantees. Identifiable grantees. Able to Baker. Baker is identifiable. Who's going to get the property? There must be some specific grantee for a proper conveyance. If I grant Greenacre to all the Jet fans in South Florida, well, if everybody knows that it's only John, then that's going to be pretty definite as to who the grantee is. If we don't know who's going to get it, there is not an identifiable grantee, a specific person, then there's no valid conveyance. So there'll be a separate identifiable grantee question, John, and a separate description one, and a delivery one? Yes, so to me, that's why a lot of these are easy. Because as long as I know each definition, I know what the facts are talking about. If the fact pattern's talking about how they're describing the property, the issue must be about the legal description, which means my answer has to be about the legal description. If I'm doing a question about who's going to get the property, oh yeah, there's a rule about identifiable grantee. Now all I need to do is pick the answer talking about the identifiable grantee. Done. Issue spotting. Don't argue. Just shut up and pick it. Good. There's a couple of rules we need to know about the transfer of title by will or law. A couple of little definitions now when the transfer of property will happen by operation of law or will. Okay, keep these separate. So one, can you transfer property by will? Yes. If there's no will, the property would pass by intestate succession. That's right, the rules of the state of intestate succession. If there's no will and I die and I own a piece of property, you're looking for the rules of intestate succession. That's what will govern where the title to the property is going to go. If there is a will, ademption. If there's ademption, I leave you land in the will, but while I'm alive, I sell it to somebody else. Are you out of luck now? Yes. If I left you the land in a will, but in the meantime, while I'm alive, I sold it to Bob, then do you get anything? No. Lapse. Lapse. If I leave you something, you're the beneficiary, and I leave you the piece of property, and you die, then you don't get it, you're dead. Where does the property go? Into the residuary estate. So if you're the beneficiary and I left you a piece of land, but you died before me, then the land generally will go into the residuary estate. An exoneration of liens. What happens if I leave you land in a will, but there were liens on the will? There's some sort of a lien, encumbrance on the property. Generally, the estate, my estate, will pay off any of those liens or any amounts of money so you can get the property clean of any encumbrances. So if you see a hypo where there are liens on the property and you were going to get it in a will, just know that generally speaking, the estate will pay the lien so you can get the property free and clear. Keep those couple of little rules about the will separate from the formality ones, delivery, acceptance, identifiable grantee, and description. That goes for the valid conveyance, which is separate from general versus special versus quitclaim deed. 3 present warranties, 3 future warranties. Everything has its own card. Everything is just a definition. I can understand it. It's not intellectually that difficult. I just need to keep all these rules separate and then focus on which one of these rules is the hypo really talking about. Good? Good. New card. New card. Adverse possession. Adverse possession. We pretty much know what this looks like. Adverse possession. Someone can acquire legal title. I can get legal ownership to a piece of property via adverse possession. What's adverse possession? I basically just go on your empty piece of property. I live there. It's a squatter. I go and live on a piece of property for this statutory period of time. I comply with the other elements, and now do I get legal title? Am I the owner? Yes, you can acquire legal title via adverse possession. Good? Just basically go on a piece of property and you just keep on staying there. What are the elements we need for you to acquire the legal title? Number 1, it has to be continuous. You have to be on that piece of property for a continuous amount of time. If the statutory period is 7 years, hypothetically, then you have to be on that property continuously for that 7-year period. There is this weird little rule called tacking. What if I'm on there for 4 years, but then I say, now look, you, Bob, you stay here for 2 years, and then I'll be back. Now you're here for 2 years, then I come back and I'm there for the last 1 year. Will that work? Yes. Tacking is when the guy who was on the land basically intentionally tries to transfer that right, if you will, to somebody else. So I'm living on there for 4 years. I call you up and say, listen, I got to leave for a couple. You come on the property. Now you take over from me. I'm literally handing you the baton, so to speak. You're looking for some intentional transfer between one person and another. Then when I come back, is it now 6 continuous years? Yes. If I'm there for 4 and I just leave, and then a couple months later you come on there, can I now say that's been continuous? No. The tacking is more of the intentional handing of the right to from one person to another. Weird exception. You'll know it when you see it. Basically, continuous is an element that you're looking for. The next 3 I lump together because they basically are the same. Actual, open, and notorious. Actual, open, and notorious. The use is obvious, so a reasonable person would know someone is using the land. Open, actual, and notorious. I'm not living in the closet. I'm not living in the bedroom. I'm doing something, I'm using the property so that a reasonable person would know, you know, there's a weird guy who's on that piece of land all the time. That's actual, open, and notorious. The use is obvious, so a reasonable person would know. The use must be hostile. The use is without the owner's permission, and I'm doing something to make it look like I'm making it my own. I'm kind of doing something to make it look like mine, and obviously I don't have the owner's permission. Hostile. And lastly, exclusive. I'm not sharing it with the owner. So adverse possession, I need continuous use for that statutory period of time. It has to be actual, open, notorious. Actual, open, notorious, which basically means a reasonable person could see it's obviously that there's somebody on there. It's hostile. I'm not doing it with the guy's consent. And I'm doing stuff to make it look like it's mine, taking it over. And it's exclusive, I'm not sharing it with the true owner. If I do all those things for the statutory period of time, will I have legal title to the property? Yes. Done. If the hypo removes any of those elements from that, now do I have title? No. Reading comprehension. Again, those are the people that know the law very well, but they don't slow down in the facts because with each one of those elements, what can they do to you on a question? They're going to remove one of the elements, make it look like adverse possession, but if it's not open, if it's not continuous, if it's not one of them, do I have legal title now? No. But you said, oh, I know this question, I've done this before. Yeah, the guy's living there for 30 years, it's going to be adverse possession. D, adverse possession. Wrong? How come I'm wrong? You're wrong because even though you memorized your card correctly, you didn't slow down and read the facts. Am I saying it's never going to be adverse possession? No, I'm saying you and I don't know which one of these versions you're going to get on the day of the bar. What I'm telling you is if you know the law cold and you slow the hell down, which one will they give you? The one that removes this element versus that? I don't know. But as long as you're reading slowly, will you be able to see it? Yes. And then can you get all of the adverse possession questions right? Yes. Slow down on the facts, know what you're looking for, then you shut up and pick it. Good? Good. Couple of separate rules now. Separate rules for drafting and reviewing and executing documents. Drafting, executing, and executing legal documents. Who can actually handle some of these documents? Couple of basic definitions now for this. Number one, for the drafting of the documents themselves. Can a non-attorney, a non-lawyer acting on their own behalf draft real estate documents? Yes. Yes, they can. Generally, will a lawyer do it? No, there are a whole bunch of reasons why it's prudent for that to happen. Yeah. But legally, can you go to Office Depot, Office Max, a lot of these stores, and buy a form document? Yes, you can. And you can execute the document on your own. A real estate broker, real estate agent, real estate broker can use form documents to fill out the contract on behalf of the clients and just fill in the blanks, the address, the amount of money, the purchase price, etc. Done. Mortgage broker also can use prepare mortgage documents, use forms, fill out the interest rate, fill out the amount of the loan, fill out the address of the property. Can they do that on their own? Yes. What's the common denominator for all these? It's not the practice of law. And what's the most important thing? They're not giving legal advice. Not giving legal advice. If they're just filling in the blanks of the form documents, they're not giving legal advice. And therefore, they're not trying to practice law, and therefore, it's perfectly legal. There's no requirement even that a lawyer does the closing, the actual transfer of title. Could a closing agent a title agent, a closing agent, or the broker do that? Yes. But again, what's the standard you're looking for? No legal advice can be given. So if there are people there just moving papers around, sign, check, sign, and no one's asking any questions, technically, could you do it without a lawyer? Yes. Exactly right. You don't want that to get around because everyone's trying to pay back their loans, and if you want to be a real estate lawyer, it's a great way to make some money, right? Ha ha ha, John, shut up, keep going, I'm sorry. So the point is, for a definitional question on MBE, does it have to be a lawyer? No. Is it okay to just fill in the blanks to draft these things? Yes, as long as you're not doing what? Giving legal advice. Filling in the forms is okay. Executing the documents, signing the documents themselves. Couple of weird rules. We talked about filling in the blanks. Now we're talking about signing and executing. An agent for the grantor, an agent for the seller, may sign a deed on behalf of the grantor, but the authority granting the agent the right to do it has to be in writing. Okay? If I'm your agent, you're the seller, and I'm going to sign on your behalf, there needs to be a piece of paper signed that says you give me permission, you give me the authority to go sign on your behalf. Why? Because doesn't everything have to be in writing? Yes. Since the deed has to be in writing under the statute of frauds, the authority for me to do it has to be in writing under the statute of frauds. So if an agent is going to execute it on your behalf, then it has to be the authority itself, the permission has to be in writing. It's called the equal dignities rule. Why? I have no idea. I'm just giving it to you so if you see the term equal dignity, you know what they're talking about. Agent acting on behalf to execute the deed. Exception. If you're an officer of a corporation and you already have the authority to sign on the corporation's behalf, now you're signing a deed for a piece of property for the corporation, you don't need a separate signing piece of paper because you already have the authority in the first place. So if you're an officer for a corporation who already has the right to do that on behalf of the company, no additional no additional writing is necessary. If you're someone whose only job it is to sign, they have these signing people who just sign at the grantor's request. Your only job is just signing pieces of paper. You'll know it when you see it. It's a weird hypo. That's why it's an exception. But if they say, John's a signing agent, he's only there to sign pieces of paper, and that's all that I'm doing, then no additional writing is necessary. Good? Good. If there was no writing, I should have had authority in writing, and there was none. There's a weird rule that says the grantor is estopped from using the lack of writing as a defense. I am stopped from using the lack of writing as a defense if I did something to show the authority that induced reliance on somebody else's part. I'll repeat. Normally, if you're going to give me the right to sign on your behalf, it has to be in writing. If there's no writing, I can't use that as a defense. The grantor cannot use that as a defense. I'm estopped, as an estoppel argument, if I did something to try to make you think I did have the authority. So it's basically like your typical estoppel thing. I can't use the defense of no writing if I tried to make you think I had the authority to do a writing. Is this a weird exception, John? Yes. Am I going to see this all the time? No freaking way. If you happen to see a question where someone was hired to do this on someone's behalf, generally you need the piece of paper that grants my permission, the authority to do the writing. If there was no writing, but I'm an officer of a company and I already have permission to do it, fine. If I'm now trying to use the fact that there was no writing as a defense, but the facts talked about that I was basically trying to induce reliance on someone else, then I can't use the lack of writing as a defense. If you see it, then you talk about it. Otherwise, keep it on the fence. What do I want you to know from these rules? I want you to know that the mortgage broker, the real estate agent, any of these professionals can always fill in the blanks to these documents. Can they not do? Give legal advice. Fill in the blanks is okay. And if generally someone's going to execute a deed on your behalf, there needs to be a writing that gives you the permission to do so. Period. Good? Good. I can do those definitions, John. Fine. Lastly, in this section, the recording statutes. The recording statutes, okay? Let's talk about that. I know you hate these, but once again, this is basically just a definition. There are three recording statutes. Race notice, notice. Couple of keys before we get into the minutia. Number one, what does the statute look like? They're going to give you language. Many of you have already seen this stuff. It basically is going to say somewhere in the hypo, no conveyance shall be good. No conveyance shall be good against, And I'm going to give you the language you need to know for a second. So they're going to give you a recording statute in the hypo. Number one, just listen. Many times there's a recording statute in the hypo, but the question is not about the recording statute, i.e. the statute is a bunch of BS. It is not relevant to the overall issue in the hypo. What is the recording statute going to look like? When do I know I'm being tested on which one of these statutes? When is it important? Listen to me. Write this down, but listen. When a single grantor, I own Greenacre, John owns Greenacre. On Monday, I sell Greenacre to Bob. On Tuesday, I sell Greenacre to Fred. On Wednesday, I mortgage Greenacre to Joe. And on Friday, I give it to Lucy as a gift. A single grantor conveys, gives, mortgages a single piece of property to multiple people. John. Mortgage, give, sell, convey. When there's multiple people from a single grantor, these four people are all going to be pretty pissed off now, correct? Hey, who's going to win? Who gets a property? Now it depends on what the recording statute says. But if I'm doing a regular question about who the identifiable grantee in the deed is, whether the deed was delivered, whether there was a legal description of the property, whether it was the right to convey or the right of warranty, which warranty they tested me on, just because they give me a recording statute hypo at the bottom, does that mean the recording statute applies? Heck no. So again, issue spotting. Many times they give you a recording statute and there's always answer choices talking about if John recorded, if John was a bona fide purchaser. Oh yeah, it's a recording statute, that must be it. No. That's why the name of John's enterprise is called, what's the issue? Issue. Is the hypo, is the whole fact pattern talking about a single grantor with multiple people? Now the recording statute applies. If it's about something else, then the recording statute's a bunch of garbage. Throw it away. Don't pick the answer talking about recording just because there's a recording statute. That alone could be worth 2 or 3 points. Good? Good. Now let's talk about the definitions of the statutes themselves. Okay? Notice statute. Notice statute. What is a notice statute going to look like? No conveyance shall be good against any subsequent purchaser for value with no notice, subsequent purchaser for value with no notice, unless the same be recorded into law. subsequent purchaser for value without notice. That's the buzzwordy phrase you're looking for, because who wins, who prevails in a notice jurisdiction? The subsequent or last, same thing, subsequent or last bona fide purchaser. Who is a bona fide purchaser? Someone who pays value and has no notice of any transaction. Pays value, no notice. Those are the two elements you need for a bona fide purchaser. I have to pay for the property and not know that there was any shenanigans going on. The innocent purchaser. So in a notice jurisdiction, subsequent purchaser for value without notice. That's the buzzwordy phrase I'm looking for in the statute. Done. Who's going to win? The last of the bona fide purchasers in the chain. Abel, Baker, Charlie, or Fred, whoever was the subsequent bona fide purchaser. I'll get to that in a second. So who is a bona fide purchaser? If you pay and have no notice. What if you're a creditor? If you just file a judgment against my property, are you considered a bona fide purchaser? No. You're a creditor. You're not a bona fide purchaser. What if how other ways could you acquire title to my property and not be considered a bona fide purchaser? How can you get title but not have paid? Gift, will, adverse possession. If I gave you as a present, if I gave it to you in my will, or you acquired it via adverse possession, like we just talked about. You now have title to the property, but did you pay me for it? No. If you didn't pay anything, can you be a bona fide purchaser? No. So if you're doing a notice statute and someone got it by gift, by will, by adverse possession, can they qualify to be a BFP? No. They can never win. What if you're a creditor in a notice jurisdiction and you file a lien against my property? You could file a lien, but are you a bona fide purchaser? No. What if you're a mortgagee? What if you gave me a loan? A mortgagee, the guy who gives me the loan, the bank, is a mortgagee a bona fide purchaser for definitional purposes? Yes. Red letter, big thing in your notes. Creditors are not bona fide purchasers. Mortgagees, the people who give you a mortgage, yes, they are considered a bona fide purchaser. What do you need to be a bona fide purchaser? Pay and have no notice. If you take it by gift, by will, or adverse possession, you may not have notice, but you didn't pay me, so you're also not considered a bona fide purchaser. It's just a definition. But know that both elements are necessary, the pay and no notice. I'll give you a hypo. Put the pencil down, just listen to me. On Monday, I sell you Greenacre. On Monday, I sell you Greenacre. You do not record the deed. On Tuesday, I sell it to Bob. He doesn't record. On Friday, I sell it to Joe. In a notice jurisdiction, who's going to win? Joe, correct, because he's the last bona fide purchaser. When I gave it to you, did you record? No. So could anybody know what the hell was going on later on? Would anybody know what I did with you? No. When I sold it Tuesday, he didn't record, so no one's going to know about that. Now on Friday, is Joe the subsequent, the last guy in the chain? Yes. Done. Hypo number 2. Listen, I convey Greenacre to you for $200,000 on Monday. You don't record. On Tuesday, I give it to Bob for $100,000. He records. On Friday, I sell it to Joe. Who wins in a notice jurisdiction? The second guy. That's correct. Because what did the second guy do? He recorded, exactly. And what's going to give notice? What gives notice to all subsequent people for the rest of time if you record your deed? Recording of your deed will put everybody subsequent to that on notice that there was a transaction. So can anybody after that claim that they're a bona fide purchaser? No, because they already had notice. I convey it to you for $200,000 on Monday and you do record. I convey it to you on Monday for $200,000 and you immediately record on Monday. Aren't you now going to win against everybody else that comes later in a notice statute? Yes, because can anybody classify themselves as a bona fide purchaser? No, because now they all have notice. So notice, recording will give everybody notice. What are the other ways to give notice? The facts would have to tell you. If it says that you took out an ad in the newspaper, you called the whole world, you put it on CNN, you put it on Facebook, yada, yada, you're looking for something in the facts that would tell you everybody else should know what's going on. What is the one definitional thing that will give you notice for everybody? Recording of the deed. Next, what if it's a race statute? If it's a race statute, who wins in a race statute? The first person to record. They don't have to be a bona fide purchaser. They don't have to, just race statute, the first person to record. So that statute doesn't need the language subsequent purchaser for value without notice. It'll just say no conveyance shall be good against whoever first recorded. There's no BFP language because you don't need to be a BFP language. The first person who recorded, no matter who they are. Lastly, race notice. Who wins in a race notice jurisdiction? The first bona fide purchaser who recorded. The first bona fide purchaser who recorded. So just being a BFP is not enough in a race notice. You also have to be the first BFP who recorded, and you'll know that they recorded because they will tell you. That's exactly right. So again, you've got Abel, Baker, Charlie, and Fred. The hypos are a little long. John, should I chart these out? Yes. But am I going to have a time problem? No, because as long as I practice, and I practice my little hieroglyphic shorthand of who recorded and who's a BFP, by the time I get to the bottom of the hypo, I already know who's going to win. Yes, that's what stops you from having to go back and reread it 5 times. So, I convey it to you for 200 grand and you don't record, BFP, okay? I give it to you for 200 grand and you record, BFP. Now nobody else can be a BFP because everybody else has notice. A creditor, not a BFP. Mortgagee, yes, BFP. As long as I know who Abel, Baker, Charlie, and Fred are, because they have to tell me, and I slow the hell down, it's just a definition. Race notice, I have to be the first bona fide purchaser who recorded. Slow down 5 extra seconds, and you'll know who and which person that may be. Yes, but the big thing is, just because they give you a recording statute, that doesn't mean that's what the whole issue is about. For the statutory language itself, I said to you, in a notice jurisdiction, notice, no conveyance shall be good against subsequent purchaser for value without notice who recorded. If you're doing a race notice, listen, if you're doing a race notice jurisdiction, no purchaser shall be good, no conveyance, shall be good against subsequent purchaser for value and without notice who first recorded or recorded first. If you're doing a race notice statute, they literally have to give you the word first. First recorded, recorded first. That's how you will know that that statute is a race notice jurisdiction. So literally, as I've said in many other topics, one word will change the whole hypo. One word. And what's that word going to be for race notice? First. So that's why John keeps yelling, slow down, read the statute. If it says subsequent purchaser for value without notice, it's at least notice or race notice. If it doesn't say anything about the timing, that's how you know it's just a notice statute. And if it says first recorded or recorded first, now you're doing a race notice statute. Take each person one at a time, pick them off who they are, definitionally speaking. You may miss a few of these till you get comfortable with how the timing works out, but as long as you begin to apply the definitions, you're actually pretty good to go. Now we'll finish up with some weird rules, albeit they're weird. I agree with you. There'll be little weird mutant typos all by themselves, but as long as you know these that I've described first, you'll have a fighting chance at these couple. And even if you missed a few of these, you just get the ones I just talked about and you're perfectly fine. Perfectly fine. This shelter rule. This is basically a situation where someone who would not normally win is sheltered, is protected by their previous grantor. Okay, sheltered. Someone who would normally lose is actually going to win. Why would they win? Because the previous grantor would prevail. Sit back and just chart this out as I give it to you, and then we'll talk about it, okay? Chart this one out. Shelter rule. O is going to give to A. I give to you. John gives to student. O gives to A on Monday, okay? And you don't record, okay? I convey to you and you don't record. Then I give to B, give the same piece of property to B, and he records, okay? B gives the property to C as a gift. I give to you on Monday, no recording. I give to B on Wednesday, he records. If I'm in a notice or race notice statute, he's going to win, correct? Because he's the subsequent bona fide purchaser. Yes? B gives to C by gift. Is C a bona fide purchaser? No, C is not a bona fide purchaser. Why? Because he got by gift. Exactly. He didn't purchase the property. So C is not a bona fide purchaser. However, between A, you, and C, between you, the first guy, and C, the subsequent grantee, C is going to win. Huh? C is going to win. You said he got it by gift. Yes, but C is sheltered by B because B would have beat you. B is the subsequent bona fide purchaser. I'll repeat. I sell it to you on Monday, you don't record. I sell it to Bob on Tuesday and he records. If I was in a notice or race notice jurisdiction, who would win? B. B then gives it to C by a present, by gift. Even though the gift means that C is not a bona fide purchaser, he got it from whom? From B. And since B would prevail against you, C prevails against you because C is sheltered. So if you see someone who's going to get it, me to you, me to Bob. But then Bob gives it to somebody by gift, by will. There's something there. We say, well, he's not a BFP. He's not going to win. But my initial transaction, my second transaction to B, he would beat you. The second person would win. That subsequent person is sheltered because B was a bona fide purchaser, so everybody who comes after B will also be considered a bona fide purchaser. Is that going to be a pretty weird hypo, John? Yes. That's why I say chart that out, mark it as a shelter, and if you happen to see a weird exception that's what that looks like, then you know to pick it. Generally, are you going to do that? No. Speaking of crazy, now we'll go to the while deed. The while deed. This basically simply means it's out of the chain of title. Out of the chain of title. Again, chart this out and we'll talk about it. Remember, most of these things always start with the same grantor. That's what you're focusing on. John, the original grantor. That's what everything is about. So, if on Monday I convey Greenacre to you, I convey Greenacre to you, and you don't record, okay? Then I convey to B. Then I convey to B. Got it? Then O, then A to B. Sorry. A to B. Let's start again. Sorry, I screwed this up. I'm pretty tired. It's pretty late. So here we go again. Okay? If O to A, then A to B. That's what it is. Me to you. Me to you. Then you give it to somebody else. You give it to B. I convey the same piece of property then to C. So we usually have me to you, then me to him. In this weird hypo, I'm conveying Greenacre to you, then you're giving it to somebody else. I'm now giving it to a third party, to Bob. Okay? Started with the original grantor. The original grantor. The A to B, you to him. You to him. When you gave it to B, would B ever know that I'm the original grantor? No. And therefore, the A to B, your conveyance to the subsequent guy on your chain, is a while deed because B would have no notice of my transactions. When you're doing this searching without getting into this minutia, because that's why I didn't want to get into it, you always go by the original grantor. So since John's the original grantor, let's go again. I'm the original grantor. I convey to you. Normally, the hypo is then immediately going to say, and then John conveys to somebody else. Single grantor, competing pieces of property. If I'm doing something where I convey to you, then you convey to somebody else, then John, original grantor, conveys to him. Now, between him and your subsequent guy, what's going to happen? He's going to win, my third grantee. Why? Because from the you to him, the original grantee, you always go back to look to see who was the grantor. So if your guy looked at you and said, oh, you're the grantor, you would never know that John was the original grantor of the transaction. There's no way to trace it back to me. So C technically would have no notice of that, and he would win because your deed to B, your deed to your guy is outside the chain of title. The chain of title always reverts back to the original grantor. John, that's really weird. I know, that's called a while deed. It's out of the chain. Where does the chain start? From the original grantor. So if I convey Greenacre to A, then A to B, then O, me, to C, That little thing from you to him, it doesn't start with me, it starts with you. That little thing out there, that's out of the chain of title. And no one would ever know that that happened, and therefore C, my next guy, would win, because it always starts with the original grantor. An exception, you may miss a few, you'll draw it out, oh, that's what he was talking about. Okay, now I totally make sense. He did a bad job explaining it. His chart wasn't very good, but now now I see this is the one we're talking about, the wild deed. Now I can get it. If you didn't, is that going to be fatal? No, I'm just giving it to you so if you happen to see it once on a practice question, you'll know what it looks like, and maybe you can get it right. Lastly, after acquired title. After acquired title. This is where I convey Greenacre to you. At closing, I'm trying to give you a deed, but I don't have title. There was a technical glitch with the title. Something was wrong and I didn't have legal title on the day I gave you the deed. Subsequently, I acquired the title. The problem was fixed. The glitch was fixed. Under the rule called after acquired title, the title automatically goes through me to you and to whoever you gave the property to. I'll repeat. I'm going to convey title to you today on Monday. For some reason, there was a glitch in the title. I didn't actually have title, but I wanted to convey it to you. There was intent. There was no problem with that. But there was a problem. I didn't have legal title. Whether it's a day, a month, or 6 months, or a year later, once I acquire the title, my problem is fixed. The title passes right from me to you and whoever the subsequent grantees are automatically. None of us can deny that the title is going to go to whoever the end grantee happens to be. So if you see on the day of closing that the grantor did not have title through some weird glitch or mistake, then subsequently acquired the title, even though he acquired it after the closing, after acquired title, will it automatically pass to whoever the grantee is? Yes, automatically, and there's nothing anybody can do about it. Again, that hypo, weird as it sounds, should stand out pretty damn obviously, because I'll have to give you all that description that now I acquired the title after the closing. What do I want you to know? The 3 recording statutes. Who's a bona fide purchaser? Slow down in the facts and be able to determine who paid for it, who had notice. Did you not pay for it? Will, gift, adverse possession. Are you a creditor? Are you a mortgagee? Definition, know them cold. Know whether the statute applies in the first place. Are they just giving you a recording statute, or is it relevant to the whole hypo? Warranty deed, quitclaim deed. Everything is a definition. You're not going to be an expert at this stuff. But out of the X number of questions you're getting, you will be shocked how many you can get right if you keep your rules separate, you focus on your reading comp, you focus on the facts, not the answer choices. Don't go rushing down there. Take the extra 50 seconds to slow the hell down. And if you make a mistake because you realize I confused those warranty and special warranty in general, go back and review the rule. Don't be doing 50 more questions 10 o'clock at night. If you know the law very well and you're missing some of these, you may be trying to do too many. You're not going to have to do 18 or 20 or 30 property questions in a row on the bar. It's not normal, especially at early in the morning or late at night. Are you reading carefully? Are you reading when you're lucid and sane and rational? Be fair to yourself. You're only going to do 1 or 2 of these at a time. That's why the hypo should begin to start to stick out by the time you get to the bar, and it should be more obvious to you. If you're not recognizing what something looks like, wait a minute, let me go to the kitchen, get a drink, come back, check my Facebook updates, whatever the hell you do. Now, okay, now I'm okay. Now I can read this. Oh, of course, this is that weird shelter thing he was talking about. Now I see it. Chart them out. If you chart them out, you will have time, because once you chart it out for the extra 40 seconds, the answer will be right in front of you, and when it is, you will put a smile on your face with tears of joy, and you will shut up and pick it. That's correct. Even on a weird property question, the whole frickin' topic is about the definitions. When it's totally weird and you don't know, dumb it down. You're not supposed to be an expert. You want to get between 6, 6.5 out of 10 of these right. Even if you're in the high 5s, if everything else is even better, you're fine. Just worry about what you can know, get the rules down, keep everything separate, reading comprehension, and by all means, even if you have to fake it, you read very, very confidently. It's all just an issue spotting exercise. My last point, remember, for property, although it goes for every topic, all 200 questions on your exam are being done by you and the whole country at that moment. No one's a property expert, even if they think they are. So when they want to get you on one of these questions, they're going to get you anyway. There's nothing you can do about it. But they're going to get everybody else in the country. But if I could know my rules a little better than the guy sitting next to me, if I'm reading the hypo a little more carefully better than him, I'm getting the extra 1 or 2 or 3 right. That's why they can't expect you to be this expert, because the whole country is being tested at the same time. No matter where you went to law school, what you got in property, how good or bad your property professor was. All they can ask you in 1.8 minutes is to know a rule and to do some reading comprehension. That's it. And that's why John says, when you don't know, dumb it down. What do you always pick? The simplest answer that the facts are talking about. Connect the dots, issue spotting. But first it has to start with know your black letter law cold, slow down with the facts, and let's go get some property questions right. Good luck. Go get them.